This is furious HOA Karens. The paint marks on my lawn became her evidence. "I am counting down," Colleen yelled, jabbing her finger at the fence panel I had just set into the ground. "You have got 5 seconds to admit this is too close to the sidewalk, or I am writing you up for obstruction and calling the tow company for your materials." I stood there with my work glove tucked in one hand, my black hoodie pulled up against the Missoula overcast, and I watched her tiny body camera blink red on her jacket. She was the landscaping committee lead for the Woodland Crossing Village Association, and she had shown up the second my contractor pulled into the driveway with the post-hole auger. I am a fire alarm technician, I work nights, and I had planned this fence installation on my one day off this week because the delivery truck was coming in 2 hours and I could not afford to lose the materials or get hit with a dumping fine. Colleen Parker did not care. She had her clipboard, her tape measure, and her purple cardigan, and she was ready to make this my problem. The fence was 6 inches inside my property line. I had the survey. I had the permit from the city. I had checked the setback rules 3 times before I ordered the materials because I knew exactly what kind of neighborhood this was. Woodland Crossing was the kind of place where every front yard decision became an enforcement opportunity, where the board claimed authority over anything that touched an easement or a sightline, and where normal life turned into a compliance hearing if you picked the wrong mailbox color. Colleen had been sending me emails for 2 weeks about my lawn edging, my trash can placement, and the angle of my driveway reflectors, and now she was here in person because a contractor had arrived during what she called quiet hours, and she claimed that made the entire project illegal. "You do not build to my standard, you pay to my standard," she said, her voice rising. "This fence is a hazard and I am going to make sure you remove it before anyone trips on your mess." The contractor, a guy named Dave with a tool belt and a skeptical expression, glanced at me and shook his head. He had worked in this neighborhood before and he knew the drill. "I have the setback marked," he said calmly. "The fence is legal. You can call the city if you want, but we are not stopping." Colleen whipped around and locked eyes with him. "Go ahead and call whoever you want. I have a committee for that," she snapped. Then she turned back to me and pulled out her phone. "I am documenting every inch of this disaster and you will be hearing from our attorney by Monday." She started snapping photos of the fence post, the dirt pile, the auger, and the scattered panels, all while narrating into her phone like she was filing a crime scene report. I stayed calm, because I had one piece of proof that would end the whole game. A week earlier, I had filed a records request with the HOA management company, asking for copies of all the landscaping and fencing rules, all the enforcement logs for the past year, and any internal emails about my address. The management company had stonewalled me, demanding a processing fee that was not in the bylaws and refusing to provide anything unless I paid up front. That refusal was in writing, and it was exactly the kind of document abuse that would flip a hearing or a small claims case. I had not told Colleen yet because I wanted her to commit to her story first, to go on record with her version, and then I would drop the proof and watch the whole thing collapse. But right now, she was standing in my driveway blocking the contractor, the materials truck was 20 minutes out, and she was threatening to mark the delivery as illegal dumping the second it arrived. I needed to move fast. I pulled out my phone and opened my email. "Colleen," I said, keeping my voice even, "I have a copy of the city permit and the survey. The fence is legal. If you want to challenge it, you need to file a formal complaint with the board and give me written notice. You cannot just show up and threaten to tow my stuff." She laughed. "Oh, I absolutely can," she said. "The HOA has enforcement authority over all exterior construction, and your little city permit does not override our architectural standards. You should have submitted an application 60 days in advance, you should have gotten written approval from the landscaping committee, and you should have scheduled the work during approved hours. You did none of that, so now you pay the price." Dave set down his drill and crossed his arms. "What approved hours?" he asked. The bylaws say construction is allowed between 8 in the morning and 6 at night. It is 10:30. Colleen glared at him. Quiet hours are determined by the committee on a case-by-case basis, she said. And today is a quiet day because I said so. That was when I saw the mail carrier coming down the sidewalk, trying to navigate around the tools and posts we had stacked near the curb. He slowed down, glanced at Colleen blocking the driveway, and gave me a sympathetic look before stepping carefully around a bag of concrete mix. Colleen did not even notice. She was too busy typing something on her phone, probably sending an emergency alert to the rest of the committee. I took a breath and made a decision. I was not going to let her derail the whole project over a fake rule. "Colleen," I said, "if you want to file a complaint, go ahead. But we are continuing the work. If you physically block the contractor or the delivery truck, that is harassment, and I will call the police." Her head snapped up. "You will not call anyone," she said. "This is HOA business and we handle it internally. If you try to escalate this, you will be facing a lien on your property and a lawsuit for violating the covenants." Dave stepped forward. "We are not stopping," he said firmly. "If you do not move, we are going to work around you." Colleen pulled out a small metal pry tool from her jacket pocket and walked over to the fence post. She jabbed the tool against the post and wiggled it, then turned to me with a triumphant look. "This is unstable," she announced. "The concrete is not even set yet, and you are already claiming it is structural. I am marking this as a hazard, and I am calling for immediate removal." I stared at her. The concrete had been poured 15 minutes ago. Of course it was not set yet. That is not how concrete works, I said. She ignored me and started taking more photos, this time close-ups of the post wiggling under her pry tool pressure. The delivery truck turned onto the street. I could see the driver slowing down, looking for my address. Colleen saw it too, and her expression shifted into something cold and calculated. "If that truck unloads on HOA property without a permit," she said, "I will have it towed immediately and you will be billed for the removal plus a dumping fine of $500. The materials were being delivered to my driveway, which was my property, not HOA property. But Colleen was already walking toward the curb with her phone out, and I knew she was going to try to intercept the driver and cause a scene. I had to act fast. I jogged past her and waved the truck driver over, pointing to my driveway. He pulled up, rolled down the window, and I explained quickly that I was the homeowner and the delivery was cleared. The driver nodded, handed me a clipboard to sign, and started unloading the fence panels onto the driveway. Colleen marched over and tried to stop him, claiming he was violating HOA access rules, but the driver just shrugged and kept working. He had a delivery order and he was not about to get involved in a neighborhood dispute. Colleen stood there fuming as the truck drove away. Then she turned to me and said, "You just made the biggest mistake of your life. I am filing an emergency enforcement action and you will be getting a hearing notice within 48 hours. You will be fined, you will remove the fence, and you will pay every administrative fee we decide to charge. You do not build to my standard, you pay to my standard." I stayed calm. I had the survey, the permit, and the records request refusal. I also had my phone recording audio of this entire interaction, and Colleen had just threatened me on tape with illegal fees and removal demands that were not in the bylaws. I did not say any of that yet. I just nodded and said, "I will see you at the hearing." She smiled, thin and mean. "You will see a lot more than that," she said, and walked back to her car. Dave waited until she was gone, then let out a long breath. "That was insane," he said. "I have been doing fences for 10 years and I have never seen someone try to stop a delivery truck over a setback complaint." I helped him unload the panels and we got back to work. The concrete set, the posts went in, and by late afternoon we had the first section of the fence framed and braced. It looked solid, it was legal, and it was exactly where the survey said it should be. But I knew Colleen was not done. She had her committee, her attorney threats, and her little body camera, and she was going to escalate this until I either caved or fought back hard. I did not plan to cave. That night I got an email from the HOA management company. It was a formal notice of violation, claiming my fence was installed without prior approval, that it obstructed pedestrian access, that it violated setback requirements, and that it posed a safety hazard. The notice demanded immediate removal, a formal hearing within 7 days, and a preliminary fine of $250, with additional penalties accruing daily until compliance. The email was signed by Colleen Parker on behalf of the Landscaping Committee, and it included a link to schedule a mandatory inspection where the committee would measure the fence themselves and determine final penalties. I read it twice, then forwarded it to my buddy Marcus, a real estate agent who had warned me about this neighborhood when I bought the place. He called me 5 minutes later. "They are trying to bully you into paying," he said. "That fine structure is not in the bylaws. They are padding it with administrative surcharges and fake legal fees to scare you into settling. Do not pay anything until you get a written breakdown of every charge and a citation to the actual rule they are claiming you broke." "I already requested the rules a week ago," I said. "They refused to send them unless I paid a processing fee that does not exist." Marcus laughed, but it was a dark laugh. "That is perfect," he said. "If they are hiding documents, you can use that in a hearing or a small claims case. Keep every email, record every conversation, and do not let them intimidate you. If they try to lien your property, you can challenge it and they will have to prove the fine was legitimate. Most of the time they cannot." I thanked him and hung up. Then I opened my laptop and started building a timeline. Every email, every photo, every notice, every conversation with Colleen. I saved the record's request refusal in a separate folder, and I made a note to follow up with the management company in writing, demanding the documents again and citing the refusal as evidence of bad faith. I was not going to let this HOA bury me in fake fees and removal threats. I was going to fight back with paper, procedure, and proof. The next morning I got another email. This one was from a law firm I had never heard of, with a letterhead that looked official but generic. The email claimed to represent the Woodland Crossing Village Association and stated that I was in violation of multiple covenants, that I had failed to respond to enforcement actions, and that the HOA was prepared to pursue immediate legal remedies, including a lien, a lawsuit, and forced removal of the fenc. My McCork's 30 Admore Gardwin's Custwani bird baths of Nout self-done, and try from town. I seen one communist who would vloyer a no treshuv there. Or there in pies, we've lost in mob 3 weeks since review to fear someone in the strace. The email demanded that I contact the firm within 48 hours to discuss a settlement, and it included a payment link for an initial consultation fee of $500. I read the email 3 times, then I looked up the law firm. It was a real firm, but they specialized in debt collection and tenant evictions, not HOA disputes. The email had no case number, no court filing, no specifics about which covenants I had supposedly violated. It was a bluff, a scare tactic meant to make me panic and pay up before I had time to think. I did not panic. I replied with a short email stating that I had reviewed the bylaws, that my fence was legally permitted and compliant, that I had documentation to support my position, and that I would not be paying any consultation fees or settlement amounts without a formal hearing and a written explanation of all charge. Stasi vrives by Porty and more Gardwin's Custwani bird baths of Pausodia, and in try from town. I see one communist who would vloyer a no treshuv there. There were there obais, there were the Loston Knob 3 weeks since review to fear someone in the Straxchen beepers, and the Strongrens frashting a dinsum jackstra fations. I copied the management company, and I copied Colleen, just to make sure everyone saw my response. Then I went to work. I was on a night shift rotation that week, so I had the mornings free. I used the time to dig through the HOA bylaws, the county code, and the city permit records. I found the exact setback rule Colleen was claiming I had violated, and I found the language that said fences were allowed as long as they were inside the property line and met height and material standards. My fence met every standard. The city had approved it. The survey confirmed the line. Colleen had no case. But she did not need a case. She just needed to create enough chaos and fear that I would give up and pay her off. That afternoon, I got a call from the HOA management company. It was a woman named Linda, and she sounded tired and irritated. She said Colleen had filed an emergency enforcement request, that the board was scheduling a hearing, and that I needed to submit a written response within 72 hours or the violation would be considered admitted. She also said the board was considering a stop work order, which would prevent me from finishing the fence until the hearing was resolved. I asked her about the records request. She sighed. "We sent you an email about that," she said. "There is a processing fee for document requests, and we cannot release anything until it is paid." I pulled up the bylaws on my screen. "There is no processing fee in the bylaws," I said. "And under state law, HOA members have a right to inspect records without being charged, unless the request is excessive. I asked for 3 categories of documents. That is not excessive." Linda paused. "I will have to check with our legal team," she said. "Please do," I replied. "And while you are at it, please confirm that the landscaping committee has the authority to issue fines and stop work orders without a board vote. Because the bylaws say all enforcement actions require a majority vote of the board, and I have not seen any meeting minutes or board resolutions authorizing any of this." Another pause. "I will get back to you," she said, and hung up. I did not wait for her to call back. I drafted a formal response to the violation notice, citing the city permit, the survey, the setback rule, and the lack of any evidence that my fence obstructed access or posed a hazard. I attached photos of the fence, photos of the survey stakes, and photos of the sidewalk showing clear pedestrian space. I also attached a copy of my records request and the management company refusal, and I noted that the refusal was evidence of bad faith and a violation of my rights as a homeowner. I sent the response to Linda, to Colleen, and to the entire board. I wanted everyone to see that I was not rolling over. 2 days later, I got the hearing notice. It was scheduled for the following Tuesday at 6 in the evening, in the clubhouse conference room. The notice said I had 15 minutes to present my case, that the board would deliberate and issue a ruling the same night, and that failure to attend would result in automatic penalties. The notice also said I could bring witnesses or documentation, but I could not bring an attorney unless I gave the board 72 hours advance notice. I forwarded the notice to Marcus. He called me immediately. "This is a rigged hearing," he said. "They are not giving you enough time to prepare, they are limiting your ability to defend yourself, and they are setting it up so the board can rule against you no matter what you say. You need to bring everything you have, and you need to stay calm. Do not let them bait you into yelling or losing your temper, because they will use that as evidence that you are a problem homeowner." "I know," I said. "I am bringing the permit, the survey, the records request refusal, and the timeline. I am also bringing my phone to record the hearing, because I do not trust them to keep accurate minutes." "Good," Marcus said. "And one more thing. If they rule against you, do not agree to pay anything at the hearing. Tell them you want the ruling in writing with a full breakdown of the charges and citations to the bylaws. Make them put it all on paper, because that is the only way you can challenge it later." I thanked him and started prepping. I printed every document, organized them into a binder, and practiced my presentation. I was not going to let Colleen and her committee steamroll me in front of the board. The night before the hearing, something strange happened. I went outside to check on the fence, and I found a bright orange violation sticker attached to one of the posts. The sticker had no signature, no date, no specifics. It just said, "Violation, remove immediately," in printed text. I pulled out my phone and took photos from every angle. Then I peeled off the sticker and put it in a plastic bag. This was evidence. Colleen had come by after dark and slapped a fake sticker on my fence to make it look official, probably hoping I would panic and tear the whole thing down before the hearing. I did not panic. I added the sticker to my evidence binder, and I made a note that Colleen had trespassed on my property to place it. That was going to come up at the hearing. Tuesday night arrived. I drove to the clubhouse and parked in the lot. There were a dozen cars already there, including Colleen's sedan with the HOA parking sticker. I grabbed my binder, checked my phone recording app, and walked inside. The conference room was small and stuffy, with a folding table at the front and rows of plastic chairs facing it. The board sat at the table. 5 people, 3 men and 2 women, all looking bored and annoyed. Colleen sat off to the side with her clipboard and her tiny body camera still clipped to her jacket. There were a few other homeowners in the audience, probably there for their own hearings or just to watch the show. Linda, the management company rep, stood at the front and called the meeting to order. She read through some procedural notes, then called my name. I walked up to the front, set my binder on the table, and started my presentation. I showed the permit, the survey, the setback rule, and the photos of the fence. I explained that the fence was legal, that it met all city and HOA standards, and that the violation notice was based on false claims. I showed the record's request refusal and explained that the management company had stonewalled me when I tried to get documentation. I showed the orange sticker and explained that Colleen had trespassed on my property to place it without any board authorization. Colleen interrupted me. That sticker was placed by a committee member acting under enforcement authority, she said. You are twisting the facts to make yourself look like a victim. I turned to the board. If the committee has enforcement authority, I said, then please show me the board resolution that granted it. The bylaws say all enforcement actions require a board vote. I have not seen any meeting minutes or resolutions authorizing Colleen to issue fines, stop work orders, or stickers. The board members looked at each other. One of them, a man in his 60s with a tie and a sour expression, spoke up. The landscaping committee has standing authority to enforce exterior standards, he said. We do not need a separate vote for every individual action. I pulled out a copy of the bylaws and read the section out loud. It said enforcement actions, including fines and removal orders, required a majority vote of the board except in emergency situations where immediate action was necessary to prevent harm. I looked up. Is my fence an emergency? I asked. Is it preventing harm? The board member frowned. It is obstructing access, he said. I showed the photos of the sidewalk with clear pedestrian space. The mail carrier walked past it yesterday with no problem, I said. There is no obstruction. Colleen stood up. Your photos are old, she said. The dirt marks and grass look different day to day. You could have taken those photos before you installed the fence, and now you are claiming they are current. I pulled out my phone and opened the photo app. I took these photos this morning, I said, and showed the timestamps. The metadata is embedded in the file. If you want to challenge them, I can email them to the board right now and you can verify the date. If you are enjoying this HOA drama, please hit the like button and subscribe for more stories where the little guy fights back and wins. Colleen sat down, her face red. The board looked uncomfortable. Linda cleared her throat and asked if I had anything else to present. I did. I pulled out the email from the fake law firm and read it out loud. Then I explained that it was a bluff tactic meant to scare me into paying a settlement. I asked the board if they had authorized the firm to represent the HOA, and I asked for proof of any lawsuit or lien filing. Linda looked at the board. The board president, a woman in her 50s with a tight expression, said, "We have not authorized any legal action yet. That email was premature." So it was a fake threat, I said, sent by Colleen or someone on her committee, using a law firm letterhead to intimidate me. The room went quiet. The board president looked at Colleen, who was staring at her clipboard and refusing to make eye contact. "This is inappropriate," the president said slowly. If there was unauthorized legal correspondence, we need to investigate that. Colleen finally spoke. I was protecting the association, she said. This homeowner is flagrantly violating the covenants and refusing to comply. Someone had to take action. Taking action does not mean sending fake legal threats, I said. And it does not mean trespassing on my property to place unauthorized stickers. If this board approves those tactics, then I will be filing a complaint with the State Regulatory Board and pursuing a lawsuit for harassment and abuse of authority. The board members shifted in their seats. The president looked at Linda. We need to table this, she said. We will review the documentation and issue a written ruling within 10 business days. I shook my head. No, I said. I have complied with every rule, I have provided documentation, and I have shown that the violation notice is false. I am not leaving here without a resolution. Either you dismiss the violation and the fines tonight, or I am filing a small claim suit tomorrow for harassment, abusive process, and the cost of my time and materials. The board president looked annoyed. We cannot make a ruling without deliberation, she said. You have all the facts right now, I replied. The fence is legal. The permit is valid. The survey confirms the property line. There is no obstruction. Dismiss the violation or I walk out and file suit. The room was silent. Then one of the other board members, a younger man who had been quiet the whole time, spoke up. I move to dismiss the violation, he said. There is no evidence of a covenant breach and the homeowner has provided sufficient documentation. The president looked furious, but another board member seconded the motion. They took a vote. 3 voted to dismiss, 2 voted to uphold. The violation was dismissed. Colleen stood up and stormed out of the room, slamming the door behind her. Linda handed me a piece of paper. This is your dismissal notice, she said. The violation is closed and no fines are owed. We will update your account by the end of the week. I thanked her, grabbed my binder, and walked out. I had won the hearing, but I knew Colleen was not going to let this go. She had been humiliated in front of the board and she was going to find another angle to come after me. I needed to stay ready. 2 days later, I got a text from Dave, the contractor. He said someone had filed a complaint with the city claiming my fence was installed without a permit and that a building inspector was coming out to verify. I called the city immediately and explained the situation. The inspector said he would be there the next morning, and he sounded skeptical of the complaint. The inspector showed up at 9. He was a middle-aged guy with a clipboard and a measuring tape, and he spent about 10 minutes looking at the fence, checking the setback, and reviewing my permit. Then he looked at me and said, "This fence is fine. Whoever filed the complaint is wasting city resources. I am closing this as unfounded." I asked him if he could put that in writing. He nodded and handed me a form. It was an inspection report confirming that the fence was compliant and that no violations were found. I made 3 copies and sent one to the HOA, one to Linda, and one to Marcus. Colleen did not respond to the inspection report. Instead, she filed a new complaint claiming that my contractor had damaged HOA common property during the installation, specifically a section of grass near the sidewalk where we had staged materials. The complaint demanded that I pay for resodding, grading, and irrigation repair, totaling $1,200. I went outside and looked at the grass. There was a small patch of disturbed dirt where we had stacked fence panels for a few hours, but there was no damage to any irrigation, no grading issues, and no reason to resod. The grass would grow back in a week. This was another fake claim meant to force me into paying something. Anything, so Colleen could claim a win. I took photos of the grass, the sidewalk, and the surrounding area. Then I sent an email to Linda and the board stating that there was no damage, that the grass was already recovering, and that I would not be paying any repair costs without a third-party inspection and proof of actual harm. I also noted that this was the 3rd false claim Colleen had filed in 2 weeks, and that her behavior was starting to look like targeted harassment. Linda replied the next day. She said the board had reviewed my email and they agreed that no repair costs were warranted. She also said the board was implementing new procedures requiring all enforcement actions to be reviewed by the management company before any notices were sent to homeowners, specifically to prevent committee members from issuing unauthorized threats. It was not a direct reprimand of Colleen, but it was a policy change that would limit her power, and I took it as a small win. But Colleen was not done. A week later, I got another email from her, sent directly to me with no board CC. It said she had conducted a walkthrough of my property and identified several additional violations, including improper drainage, unapproved landscaping, and trash storage visible from the street. She demanded a meeting within 48 hours to discuss compliance, and she threatened to escalate to the board if I did not respond. I did not respond to her email. Instead, I forwarded it to Linda and asked if Colleen had been authorized to conduct property inspections or send enforcement demands directly to homeowners. Linda called me an hour later and said no, Colleen did not have that authority, and the board was going to have a conversation with her about overstepping her role. That conversation must have happened because the emails stopped. For about 2 weeks, I heard nothing from Colleen or the landscaping committee. I finished the fence, cleaned up the yard, and went back to my normal life. I thought maybe the conflict was over. Then I got a notice in the mail. It was from the county courthouse, and it was a summons for a small claims hearing. The plaintiff was the Woodland Crossing Village Association, and they were suing me for unpaid fines, property damage, and breach of covenants, totaling $3,000. I read the complaint. It was a mess. It claimed I had installed a fence without approval, obstructed access, damaged common property, refused to comply with enforcement actions, and caused the HOA to incur legal and administrative costs in pursuing the matter. It cited the original violation notice, the fake law firm letter, and the grass damage claim, all of which had been dismissed or debunked. It was a Hail Mary lawsuit, thrown together by Colleen or someone on the board, hoping I would settle rather than fight. I was not going to settle. I called Marcus and told him about the lawsuit. He laughed. "This is the dumbest thing they could have done," he said. "You have documentation proving every claim is false, you have emails showing they refused to provide records, and you have proof they sent fake legal threats. You are going to destroy them in court." I hired an attorney, a local guy named Tom who specialized in HOA disputes. He reviewed my evidence and said the case was a slam dunk. He filed a response denying all claims, and he filed a counterclaim for harassment, abuse of process, and the cost of defending myself. He also filed a motion to compel the HOA to produce all records related to enforcement actions, meeting minutes, and committee authorizations, which they had been refusing to provide for months. The court ordered the HOA to produce the records. 2 weeks later, Tom received a box of documents from the management company. Inside was every email, every meeting minute, and every enforcement log for the past year. And buried in the pile was a smoking gun. It was an email thread between Colleen and the management company, dated 2 weeks before I filed my records request. In the emails, Colleen told Linda to withhold any documents related to enforcement actions unless homeowners paid a processing fee, even though the bylaws did not authorize such a fee. Linda replied that the fee was not enforceable, but Colleen insisted it was necessary to discourage frivolous requests. The thread showed that Colleen had been deliberately hiding documents to prevent homeowners from challenging her enforcement tactics, and that the management company had gone along with it, at least initially. Tom made copies of the email thread and attached it to our counterclaim. He also filed a motion for sanctions, arguing that the HOA had engaged in bad faith litigation by filing a lawsuit based on claims they knew were false and by withholding documents required by law. The small claims hearing was scheduled for a Thursday morning. I took the day off work and met Tom at the courthouse. The HOA was represented by a different attorney, a woman who looked exhausted and underprepared. Colleen was there too, sitting in the back row with her clipboard and her tiny body camera, looking smug. The judge called the case. The HOA attorney presented their complaint, reading through the list of alleged violations and damages. She did not have much evidence, just copies of the original notices and a few photos of my fence. The judge asked if she had any documentation proving the fence was non-compliant, and she admitted she did not, because the city had approved the permit and the inspection had found no violations. Then Tom stood up and presented our defense. He showed the permit, the survey, the inspection report, and the timeline of false claims. He showed the records request refusal and the email thread proving Colleen had been hiding documents. He showed the fake law firm letter and explained that it was an unauthorized threat sent to intimidate me into paying. He showed the orange sticker and explained that Colleen had trespassed on my property to place it. And then he showed the video. I had not mentioned the video yet, because I was saving it for the right moment. A week after the hearing at the clubhouse, I had installed a doorbell camera that covered my driveway and the front yard. The camera had caught Colleen coming onto my property 3 separate times, always after dark, always alone. In one video, she was measuring the fence with her own tape measure. In another, she was taking photos of the grass. In the third, she was placing another orange sticker on a fence post, then walking away quickly. Tom played the videos on a laptop. The judge watched in silence. When the videos ended, he looked at the HOA attorney and said, "Did your client authorize this behavior?" The attorney looked at Colleen, who was staring at the floor. "I will have to confer with my client," the attorney said. The judge shook his head. "This case is dismissed," he said. "The plaintiff has failed to prove any violation, and the evidence shows a pattern of harassment and abuse of process. I am awarding the defendant costs and attorney fees, and I am ordering the plaintiff to cease all enforcement actions related to this fence unless they can provide clear evidence of a covenant breach. If I see this case again, I will consider sanctions." The gavel came down. Colleen stood up and left the courtroom without a word. The HOA attorney apologized to Tom and said she would work on getting the costs paid immediately. The judge signed the order and handed it to the clerk. I walked out of the courthouse with Tom. We shook hands and he said, "That was the cleanest HOA case I have seen in years. You did everything right. You kept records, you stayed calm, and you let them hang themselves with their own behavior." I thanked him and drove home. When I got there, I checked my email. There was a message from Linda at the management company. It was a formal notice stating that the HOA had dismissed the lawsuit, that all fines and penalties related to my fence were voided, and that the board had issued a written warning to Colleen Parker for exceeding her authority and engaging in harassment behavior. The notice also said the board was implementing new oversight procedures for the landscaping committee and that all future enforcement actions would require board approval before any homeowner contact. It was not a full apology, but it was close. The HOA had lost in court, they had paid my costs, and Colleen had been reprimanded. I had won. But I was not done yet. I had the records request refusal, the email thread, and the video evidence, and I wanted to make sure no other homeowner had to go through what I had just gone through. I filed a complaint with the state regulatory board that oversees HOA management companies, attaching all of my documentation and asking for an investigation into the Woodland Crossing Village Association management practices. I also sent a letter to the board requesting a special meeting to discuss policy reforms, specifically around transparency, document access, and committee oversight. The board scheduled the meeting for the following month. I showed up with Marcus and a printed agenda. There were about 20 other homeowners in the room, all of whom had heard about the lawsuit and wanted to know what was going on. I presented my case, explained the document hiding scheme, and proposed 3 reforms: mandatory document access without fees, a requirement that all enforcement actions be approved by the board before any homeowner contact, and a complaint process for homeowners who believed they were being harassed by committee members. The board voted to adopt all 3 reforms. Colleen was not at the meeting. According to Linda, She had resigned from the landscaping committee the week after the court hearing. A few weeks later, I got another email from Linda. It was a formal apology on behalf of the board, acknowledging that I had been subjected to improper enforcement tactics and harassment, and confirming that all records related to my property had been cleared of any violations or fines. The email also included a check for the court-ordered costs and attorney fees, plus an additional payment covering the records request fee I had been improperly charged. I deposited the check and filed the email with the rest of my evidence binder. Then I went outside and looked at my fence. It was solid, legal, and exactly where it was supposed to be. The grass had grown back, the posts were straight. The gate swung smoothly. It was just a fence, but it had cost me weeks of stress, hundreds of dollars, and more paperwork than I ever wanted to see again. But I had won. And more importantly, I had changed the rules so the next person would not have to fight as hard. A month after the lawsuit ended, I was outside trimming some bushes when I saw a moving truck pull up across the street. A young couple was unloading boxes, and they waved when they saw me. I walked over and introduced myself. They said they had just bought the place and they were excited to join the neighborhood. I smiled and said, "Welcome to Woodland Crossing. If you ever get a notice from the HOA, read the bylaws first, and do not be afraid to push back. They count on people being too scared or too tired to fight." The couple looked confused, so I gave them a short version of my fence story. Their expressions shifted from confusion to alarm to laughter. The woman said, "That is insane. How did you deal with it?" I kept records, stayed calm, and let them make mistakes, I said, and I had help from people who knew the system. If you ever need advice, let me know. They thanked me, and we exchanged numbers. As I walked back to my house, I realized I felt lighter. The fight was over. The fence was done. The HOA had lost. Colleen was gone. And I had my proof that standing up to bullies, even HOA bullies, was worth it. That night I got one more email from the State Regulatory Board. They had completed their investigation into the Woodland Crossing Village Association, and they had found multiple violations of state HOA law, including improper document withholding, unauthorized enforcement actions, and failure to follow proper hearing procedures. The management company had been fined, and the board had been ordered to implement corrective training and new compliance protocols. The email thanked me for filing the complaint and said my documentation had been instrumental in the investigation. I closed the laptop and leaned back in my chair. It was finally over. The HOA had lost. Colleen had been reprimanded. The management company had been fined. The policies had been reformed. And I had my fence, legal and standing, exactly where it was supposed to be. A few days later, I ran into Marcus at a coffee shop. He asked how things were going, and I told him about the state investigation and the reforms. He laughed and said, "You just made life better for every homeowner in that neighborhood. That is a win." I shrugged. "I just wanted my fence," I said. "Sometimes that is all it takes," he replied. "One person willing to fight back and not give up." He was right. I had not planned to become an HOA reform advocate. I had just wanted to install a fence without getting harassed, fined, or sued. But the process had taught me something important. Bullies, whether they are HOA board members or landscaping committee leads or management companies, count on people being too scared or too tired to fight back. They count on confusion, intimidation, and fake authority. And the moment you call their bluff, the moment you demand proof and documentation and due process, they crumble. Colleen had tried to bully me with fake fines, fake legal threats, fake stickers, and fake damage claims. She had trespassed on my property, hidden documents, and filed a lawsuit she knew was baseless. And in the end, she lost everything. Her committee position, her credibility, and her ability to terrorize other homeowners. The HOA lost in court and paid my costs. The management company got fined by the state, and I got my fence, my vindication, and a set of reforms that would protect the next person who stood up to them. I finished my coffee and headed home. When I pulled into my driveway, I looked at the fence one more time. It was just a fence. But it was my fence, built legally, standing firm, and proof that you do not have to roll over when someone with a clipboard and a fake badge tries to push you around. The next weekend, I hosted a small barbecue for the neighbors. The couple from across the street came, along with a few other homeowners who had heard about the lawsuit and wanted to hear the full story. I told them everything, from the first confrontation with Colleen to the courtroom victory to the state investigation. People laughed, people shook their heads, and people asked questions about the bylaws and the new reforms. One guy, an older man who had lived in the neighborhood for 15 years, pulled me aside and said, "I wish I had done what you did. I paid a bogus fine 5 years ago because I did not know I could fight it. You just saved a lot of people a lot of money and stress." I told him he could still file a complaint if he had documentation, but he shook his head. "It is too late for me," he said, "but I am glad you did it." We went back to the barbecue and I flipped burgers and told stories and felt, for the first time in months, like I was part of a real community instead of a combat zone. The fence stood in the background, solid and legal, a reminder that sometimes the right fight is worth fighting. A few months later, I got a letter in the mail from the HOA. It was an invitation to join the Architectural Review Committee, which had just been reformed under the new oversight policies. The letter said the board was looking for homeowners who understood the rules and were willing to help create a fair and transparent process. I thought about it for a day. Then I declined. I had spent enough time dealing with HOA drama. I just wanted to live in my house, work my night shifts, and enjoy my legal fence in peace. But I kept the letter, and I kept all of my evidence binders, just in case. Because I knew there would always be another Colleen, another board member who thought rules were weapons instead of guidelines, another committee lead who confused authority with power. And the next time someone tried to bully a homeowner in Woodland Crossing, they would find out that the rules had changed, that documentation mattered, and that one person with a tape measure and a backbone could bring the whole enforcement machine to a halt. One afternoon a few weeks later, I was out front doing some yard work when a car pulled up, and a woman got out. She introduced herself as the new landscaping committee chair, appointed by the board after Colleen resigned. She was polite, friendly, and she said she just wanted to introduce herself and let me know the committee was operating under new guidelines that required transparency and board approval for any enforcement actions. I thanked her and we talked for a few minutes about the fence, the lawsuit, and the reforms. She said she had heard the whole story from Linda and she thought I had done the right thing. She also said the committee was now focused on education and voluntary compliance instead of fines and threats, and she hoped the neighborhood would feel less like a battleground going forward. I appreciated that, I said, and if you ever need a homeowner perspective on a rule or a proposal, let me know. I am happy to help as long as it does not involve another lawsuit. She laughed and said she would keep that in mind. Then she got back in her car and drove away. I went back to my yard work. The grass was green, the fence was standing, and the neighborhood was quiet. For the first time since I had moved in, I felt like I could relax. But I never forgot the lesson. Power without accountability is just bullying. Rules without transparency are just weapons. And a homeowners association that hides documents, sends fake legal threats, and lets committee members trespass and harass is not a community. It is a scam. Colleen had learned that lesson the hard way. The HOA had learned it in court. And I had learned that standing up to bullies, even when it costs time and money and stress, is always worth it in the end. The fence still stands. The rules have changed. Colleen is gone. And I have my proof, my documentation, and my story ready for the next person who needs to know that you do not have to roll over when the HOA comes knocking. I hope you enjoyed this HOA drama.